I want to turn to the dissent, Carrie, and there was the dissent was written by Justice Sotomayor. We also had from Elena Kagan, from Ketanji Brown Jackson. But I want to start with Justice Sotomayor, and I believe I'm going to pull up, just for the control room, the first Justice Sotomayor. Never in the history, so this is what she said, never in the history of our republic has a president had reason to believe that he would be immune from criminal prosecution if he used the trappings of his office to violate the criminal law. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of that office misuses official power for personal gain, the criminal law that the rest of us must abide will not provide a backstop. With fear for our democracy, I dissent.
It's a very strong statement by Justice Sotomayor, and it's understandable from the context of how broad the majority seems to interpret immunity in this case. The majority doesn't just say that the former president is immune for official acts, which it makes very clear. It also really broadens it out, and there's a part that I want to point to in the opinion where it says the immunity we've recognized extends to the outer perimeter of the president's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority. And so I think, although the court in this case really hands it back down to the lower court in this specific case involving former President Trump, it is tipping the scale for the lower court to really take a very expansive view of what official acts are. So this is a court of confusion in some ways. It tosses so many things back to the lower courts.
And let me just give one specific example that she was talking about, Sotomayor. She talks about what if the president orders the Navy SEAL Team 6 to assassinate a political rival, immune, organizes a military coup to hold on to power, immune, takes a bribe in exchange for a pardon, immune, 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 immune.
I'm not sure that's accurate. I mean, it's a bit hyperbolic, but I think what that does is nicely underscore that we're going to have some really difficult decisions to make. It's not clear whether there would be immunity. I mean, a district court judge could easily look at that scenario and say, no way. I find that ordering an assassination of a rival through SEAL Team 6, that's out of the scope. So I don't necessarily agree with that extent, but she's right. We now have some very difficult problems to wrestle with.
I think she's a lot closer to right than wrong.
Yes.
I think that when you combine her concerns with the way they articulated this position again and again and again, they come back to this idea that, oh, this immunity is absolutely necessary. Not only is it constitutionally required by separation of powers, but if without it, a president would be chilled from taking bold and decisive action. They repeat that again and again and again. So basically what you have here is the Supreme Court imposing its judgment that that principle, that we must have bold and decisive presidents, is more important than the principle that Justice Sotomayor is advancing, which is we should have presidents who obey the law.
Back with the team here in New York. Tim Naftali, you're a presidential historian. You focused a lot on Nixon. What do you make of this?
This decision was written as if America has never had a corrupt president. This decision is blind to the ways in which presidents have used their core constitutional authorities to hurt the American people. In the 1970s, the Congress of the United States, the courts, and the American people pushed back against something that was called the imperial presidency. The imperial presidency was one that used the color of national security, one of the core presidential authorities, to wiretap people, to break into their homes, to break into their psychiatrist's office, Daniel Ellsberg, to audit their IRS files, all under the color of what the Supreme Court would describe today as a core constitutional authority. Now, those were official acts according to this court, because according to this court, your motive as president doesn't matter. If you do this in order to hurt an American citizen you don't like, to hurt a political opponent, according to this court, it doesn't matter. You have just talked to the CIA, you have just talked to your Attorney General, you have talked to the Secretary of Treasury. By doing so, you are engaging in an official act. This opens the door to abuses of power, the kinds of abuses of power that we had in the Cold War at a time of the imperial presidency. It is beyond belief that a court of people who lived through the 1970s would have forgotten how it was that Richard Nixon abused power.
I mean, I think that's being generous. There are a lot of people, I think we underestimate this, a lot of people on the right who are conservatives, Republicans, whatever you want to call them, who believe that those Nixon decisions were wrongly decided, who believe that the president did and does have way more power than was applied in that Nixon example. So the fact that this is a sort of redo of the Nixon era is not surprising in the least to me, because that has been a project on the right for a long time. And one of the interesting things, I mean, I was reading pretty closely Amy Coney Barrett's dissent in part, because she addresses some of the key parts of this. One is that she says it's not right to say that there are not official things that can also be criminal, and that Congress has a say in that, that criminal law has a say in that, and that pushing this to the district court is a justice delayed, justice denied kind of scenario in which you could delay the adjudication of these issues so much so that justice is never seen. And then on top of that, the idea that you can't take evidence of official acts and use them in criminal prosecution, taken together, all of those things say that even in the areas where they say a president can be criminally prosecuted, the bar becomes so high that it creates huge roadblocks that this will happen in any particular case. And I think it's not something that is like completely out of the realm of possibilities. I mean, we are living through it right now.
Joey Jackson, just from a legal standpoint, this now moves to lower court.
So I'm concerned. I'd go pretty far in my view. I think it's a disgrace. Let me express why. We look to the Supreme Court for clarity. We look to the Supreme Court to be definitive and give definitive determinations. There's no definitive determination here. They gave uncertainty. They gave more litigation. They gave instances where you can go back to the district court just to be appealed again. And where does it come? To the Supreme Court. That's number one. Number two, when you look at a court, you look at courts to give that guidance, and they should be nonpartisan. One of the reasons you want to talk about 70s, founding fathers, and 200 years ago is because you give lifetime tenure so that you can make a decision. And that decision, you know what? You're here, doesn't matter. The reality is that so partisan, we need to have confidence in our institutions for our institutions to be respected by people. And so you have 6 conservative justices protecting the president, and 3, okay, Amy Barrett perhaps dissented in part, but 6 Supreme Court justices protecting the president, and the other 3 liberal justices saying, are you kidding me here? And then you have, to Tim's point, you cannot use the president's motivation as evidence. You can't use the president's discussion with Department of Justice officials or advisors as evidence. What is that? And so I just thought that when I'd see an opinion, it would provide some direction, it would provide some clarity. This seems to me to be protection and cover, and this is going to go on for years ad infinitum, and I'm concerned.